Hello guys, welcome back. So in the last session, we learned about the definition of copyright, two doctrines, its scope, and a bit about symbols of copyright. Now continuing within the same line of thought, today we will learn about the period of protection, neighboring rights, and ownership of copyrights. So without further ado, let's jump onto today's session. Now first let's talk about the period of protection. Okay, now TRIPS, which is trade related aspects of intellectual property rights, they suggest that the minimum period of copyright protection should be at least 50 years. However, in India, in case of original literary, dramatical, musical or artistic work, the time period of copyright protection is 60 years plus the author's lifespan. Now, what happens when one work is created by multiple authors? So in that case, the term is 60 years after the death of the last author. Okay, now when we talk about stuff like cinematographic elements or sound recordings or photographs or even the government documents, the copyright protection consists of 60 years from the year of publication. Okay, and also when we talk about sound recordings, the copyright protection period will be 60 years from the end of the year in which that sound was published for the first time. Now, also keep in mind that broadcast reproduction rights are valid for 25 years from the year of the broadcast, and performer's right lasts for 50 years from the year of when the piece was performed. Now, of course, copyright is used to protect author's right, and sometimes these two terms are used interchangeably. But when we look in a wider context, there are other related rights as well. So let us study more about those related rights today. Okay. Now, the TRIPS agreement covers in Article 14 three categories of related rights. So the first one is rights of performers, then producers of phonograms, and broadcasting organizations. So to better understand this, think of your favorite song, okay? Now in that song, there must be a lyricist, right? So the right of that lyricist must be protected under copyright. Hence, they are also known as author's right. However, it is understandable that there are other people or other elements that come together to produce your favorite song. So they might be directors, producers, or instrumentalists, or so on. So the right of those people, of those role players, are protected under related rights. So the Rome Convention for Protection of Performers, Producers of Phonograms and Broadcasting Organization of 1961 protect the rights of these people that come under the scope of related rights. Now, in context of India, creative copyrightable work is protected under Copyright Act of 1957. So when we talk about concepts of ownership and authorship, Copyright Act of 1957 makes rules to govern both of them. So let us study more about this. Okay. So when we talk about authorship, we already know and have studied before, it refers to the individual or group who creates a work. So it can be a book, music or film, and they are recognized as the original creator. But when we talk about the concept of ownership, it refers to the entity or the person holding the legal rights to exploit the work in whichever way they seem fit. So the concept of ownership is governed by section 17, and generally the author is the first owner of their work. However, in certain exceptions where the ownership might shift or the contractual or employment relation might change, this act provides several protection for them as well. For example, in section 17C, the work which is made during employment, the employer is the first owner unless there is an opposing agreement. So for example, if you make a research paper while working for a public think tank, then the ownership of that document will be situated to the think tank only unless there is a prior contract which states that you will be the first author of your own produced work. Or if you work in a corporate setting and you create a coding software, then the ownership of that software will be under the company instead of you, and you cannot claim ownership for that after leaving the company. Now, Section 17B talks about commission work like photographs, paintings, or cinematographic materials, where the person who has commissioned for that particular work to be made is the original owner and not the person who is creating it. So, for example, if you ask your friend to create a portrait for you in exchange of money, then you will be the original author unless negotiated otherwise. Now the question remains whether ownership can be transferred from one person to another. So of course the answer is yes, and it is done through the section 19 of this act. Now this process of transfer is also known as assignment, and it has to be done in a written format. So the document should involve the work, the rights assigned, the duration of the assignment, and the territorial extent to which it is applicable. And lastly, of course, any royalty which is payable. Then it should be signed by the assigner or their agent. If the duration of transfer is not mentioned, then automatically the course of 5 years is assumed from the date of assignment. Also, if the territory is also not mentioned, then the entire India, of course in the context of India, the entire country is applicable. So these two concepts of duration and territory were confirmed in cases like Pine Labs Private Limited versus Gemalto Terminals India Limited. So what happened was, Pine Labs was hired by Gemalto in 2004 to develop a software. So a contract was signed which said that Pine Labs would assign the copyright of the software to Gemalto. However, the contract did not mention two key details of how long the assignment would last and in which countries they could use it. Now, several years later, Pine Lab discovered that Gemalto was still using the software and was also planning to expand it abroad. So, Pine Labs argued that the assignment had already been expired after 5 years, so the rights had to revert back to them. But Gemalto maintained that it still held the rights under the agreement. So finally, Delhi High Court examined the matter and they decided in favor of Pine Labs. So the court also held that because the contract lacked a clear timeline and territorial scope, the legal default provisions applied here. This meant that copyright assignment automatically ended after 5 years and the rights reverted back to Pine Labs. Okay, so this case is very significant for the software and IT industry because it highlights the need for precise drafting of copyright contracts. So if the agreements are vague, the law will impose its own limits and the assignee may lose rights unexpectedly. So this judgment also reinforces the importance of explicitly stating the duration and the territorial scope of copyright assignments. Okay, I hope this is clear. Now, to strengthen our understanding even more, let us learn the difference between authorship and ownership. So here when we talk about authorship, the person who has created the original work is known as its author. But the person or the entity that holds the copyright is considered as its owner. Now, author can be the creator of a work, like they can be the writer or the composer or the photographer. But when we talk about the owner, they may initially include the author, but then they may shift to the employers or maybe commissioners or the government. Now, when we talk about the transferability of these rights, in authorship, they are fixed and they cannot be transferred. So if you write a book, then you will be called the author of that book for its eternity. But in ownership, they can be transferred via the process of assignment. So from the employer to the employee or from the commissioner to the creator. Now these rights can be transferred for a certain period of time, and if not mentioned explicitly, then of course for 5 years. Now when we talk about the duration, then authorship is permanent. So even after your death, you will be called the author of your work. Now last but not the least, let's talk about the scenario of orphan work in India. So now when we talk about an orphan work, it is like any other creative work. So it can be a book, photograph, song, painting, film, or anything. The only difference is that author or the copyright owner cannot be identified or traced. These works are also under copyright protection, but the only difference is that there is no clear way to get permission for their use. Now when we talk about India, Copyright Act of 1957 deals with this issue under section 31A. So this section provides a special mechanism for using orphan works. Now if someone, it may be a publisher, researcher or a filmmaker, so if they want to use a work but they cannot find its copyright owner, then they can apply to the copyright board. Now this applicant must show properly that they have made a genuine effort to locate the owner, but they have failed to do so. Now if the board is satisfied, they can allow the applicant to publish or use the work for a minimum period of time. And the applicant may need to pay a royalty amount which is deposited to the board only. And later, if the true copyright owner shows up, they can claim the royalty. But if not, then it will remain to the board only. Now what happens with this? This particular system balances two things. So the first one is that it encourages access to creative works that would otherwise remain locked away because no one knows who owns them. And the second one is that they protect authors' right. So if the real owner eventually is found or if they show up, they don't lose out completely. So they can still claim authorship or royalty, right? Although with each system there are pros and cons. So the system is all it also has some challenges. Now many people argue that this process is very slow and bureaucratic. So it makes it hard for libraries, researchers to actually use orphan works. And in practice, this means that many orphan works still remain unused till this day. So one more question is, what happens to the copyright protection duration if we don't know when an orphan work was published? So for such cases, section 31A steps in, and instead of declaring the work free or in public domain, the law allows people to apply for a license to use it. So of course, after the applicant has provided that they tried hard to find the owner, after this assessment, they may claim the license and the copyright board then permits use for a fixed term, and the royalties are held until the owner comes forward. Now, even if we don't know the exact publication date, the law assumes that normal duration still applies here. Okay, so if the author is completely unknown, the work won't be considered expired just because the particular information is missing. And the work will only truly fall into the public domain once the maximum possible duration can safely be assumed. But at the same time, this also creates a legal limbo. So the work is not free for use, but its protection period also cannot be easily calculated or approximately calculated. And that is why the license system exists, to avoid leaving the work locked in forever. So in short, copyright duration does not vanish just because the dates are unknown. I hope this is clear. Okay, so that is it for today, and I really hope that you enjoyed today's session. Now tune into next session to learn about the limitations and exceptions, and also about infringements and 3 types of remedy provided. In the last session, we will learn how to register a copyright in India. Perfect. Thank you so much for coming in today. I am Bhargavi and this is Vaquill.